Well, good morning, everyone, and welcome to One Civil Law. I hope you're having a great day. And for today's stream, we're going to be doing U.S. Supreme Court cases. It is that time of the year. For those of you who don't know how the U.S. Supreme Court works, they meet from the first Monday of October until the last day of June. Although, like last year or the year before, they stretched it into like the first day of July or something, which was exciting. Right? They went overtime and went into like the third day of July or something. But in any event, they work from the first Monday of October until the last day of June. And as a function of that, obviously they start hearing oral arguments in October. And so they're going to start coming out with decisions like in December. And for a whole combination of reasons, the more controversial cases tend to get pushed later in the calendar, not for the least of reasons they need more time, right? So you need more time to write the decision. And they also sometimes tend to get argued a little later in the calendar, just for whatever reason that seems to be true. But in any event, by virtue of various features, the more controversial cases, not universally, of course, there are controversial cases that come out other times of year, but a disproportionate number of the controversial cases come out in June, right? And it's normally throughout the year you'll see like a decision here, a decision there, and we saw like 6 decisions like on Tuesday and like 6 decisions last Thursday and like 6 decisions like the week before that, right? So we're just pumping out those decisions. We're pumping them out like it is going out of style. And so we're going to start to catch up on the U.S. Supreme Court because that's how I roll and that's how I do. And I love the Supreme Court because I think it's the best. Because not always, but frequently, you are pushing law to its highest. The Supreme Court sometimes, and more often than you would expect, the Supreme Court sometimes and more often than you would expect deals with fairly mundane and somewhat banal cases. Not to say they aren't important, but sometimes they're a little esoteric and in the weeds. And you read them and you're like, well, I guess it was important to somebody, but sometimes it's, not every case is Roe versus Wade or Brown versus Board or, not every case is of that magnitude. Some cases are just kind of like, eh. But, from time to time, you get cases that really push you and they elevate you. And then, of course, sometimes I get stumped because you are pushing a bunch of competing principles and I don't quite know what to do sometimes. And so sometimes those decisions are a lot of fun because I learn things along the way and I try to figure out things and they can be exciting and very interesting. So I think it's fun. And so we're going to do it and all that good stuff. I also wanted to spend just a moment yesterday sort of commenting a little bit about we did a Supreme Court case yesterday dealing with the state of Tennessee passed a law forbidding medical treatments for transgender purposes for youth under 18. So no hormone blockers, no puberty blockers. You can give the drugs for other purposes because the drugs have other medical purposes. So if they have some other condition that those drugs would treat, then that's fine. But you can't give it for those purposes. Okay. And the Supreme Court upheld that decision 6-3, which was not surprising to me. And then we read a little bit of the dissent and, I lost the will to live because it was so stupid. But, it wasn't surprising to me. What was a little surprising to me was some of the discussion you and I in chat were having, because it seemed like some of you were not understanding what I was saying and when we were doing a hypothetical. And because I was watching back some of the chat as I do, I watch back my own streams sometimes. I was watching back some of the chat as I do and watching you guys and sort of what you were saying. And I'm like, what is the point of confusion here? I'm not quite sure. Now, sometimes I'll listen back to myself and I'm like, oh, I was unclear. I misspoke. I didn't phrase something right. I used the wrong word. So sometimes I'm like, oh, I understand what the confusion is. But last time I watched it back and I'm like, I don't understand quite what the confusion is. I don't quite understand where we're having a split of misunderstanding. So we were talking about, I don't remember exactly, well, we were comparing it to a whole bunch of situations. And we were talking about this case Bostock from a couple of years ago, right? In Bostock, they dealt with employment law. Okay. It's illegal for an employer to discriminate, for example, on the basis of sex. It's Title VII. Okay. You can't discriminate on the basis of sex. And the US Supreme Court said, well, that also applies for being gay. Because in order to determine whether or not someone's gay, it is based on their sex, because it is, right? And it's like, and so I was trying to deal with this hypothetical and trying to explain this, and people were confused. So I said, well, suppose a person is sexually attracted to males. How do we know if the person is gay? And I said, well, because the person themselves is male, which is true. And apparently there was confusion about this. Some people in chat started saying other things. Like, I tried clarifying. I saw one comment in chat saying, I understand you perfectly. You're saying women can't be gay, which isn't what I said. I didn't say women can't be gay. I said this person, in order for them to be gay, would have to be male because they're sexually attracted to men. This person, if they were a woman, couldn't be gay because this person would be attracted to men, so they're not gay. That isn't to say that women can't be gay. It's to say this person can't be both a woman and gay. That doesn't make any sense. In order for this person to be gay, they must be male because that's what it means to be gay, right? That you're attracted to the same sex. This person is attracted to males. So the only way for them to be gay is for them to be male, right? Right. So am I saying women can't be gay? No. I'm saying that if this person is gay, they must be male because that's just the definition. And there seemed to be other confusion surrounding this point, which was very weird. And I didn't quite understand what we were arguing about. It was very, very strange. Somebody said, like, for example, I'd have to ask him something. I'm like, no, you don't. You don't have to ask him anything because I've told you everything you need to know. I've told you they are sexually attracted to men because it's my hypothetical, right? This is just, I'm just establishing it because I'm God of the hypothetical. They are in fact attracted to men. It is a fact. So you don't have to ask them anything. What are we doing here? It was very, very weird. It was a very weird discussion. Yeah, it was a very weird discussion. And I didn't quite understand. People were very mad at me. People were saying, like, you were saying women can't be gay. I was like, I'm not saying any of these things. I don't understand what we're having an argument about. I just don't get it. So, like, I was like, yeah. So because it's like, okay, like, okay, how do you like this person is attracted to men? It's like, if you would fire them because they're gay, that must mean that they're male, right? If you want to discriminate against gay people, if that's your goal, if you want to discriminate against gay people, the only way to do that is to discriminate on the basis of sex, because that's what makes someone gay or not, is their sex relative to what they're attracted to. So to discriminate on the basis of their sexual orientation is inherently to discriminate on the basis of their sex, because there's no way around it, right? There's no way for me to discriminate against you because you're gay without me discriminating against you because of your sex. They're one and the same. So it's like, I don't know what we're arguing about. I was very confused. Right? So I didn't know what we were arguing about. It was very weird. Yeah. Yeah, exactly. James says, I could say I like apple pie. And so some people say is what you're saying is you hate pecan pie. Like, no, like, that's not what I'm saying at all. Like, if I said I like apple pie, you're saying you don't like pecan pie? No, I'm not even saying I don't like pecan pie. I'm not even saying that I like apple pie more than pecan pie. If I say I like apple pie, you don't know what I feel about pecan pie. Maybe I like pecan pie even more. You have no clue. It's like you have no idea what my thoughts on pecan pie are from the statement, I like apple pie. So it's like, I don't know what we're talking about. It's very, very weird. Yeah, I don't know if they were locked into gay versus lesbian. That wasn't the issue. Like if you want to call a woman who's attracted to women gay, if you want to call them gay, I'm fine with that. I don't care. I mean, that's fine by me. But like, if you call them gay, what would make them gay? Right? So if you want to say that a woman who's attracted to women is gay, well, what makes them gay? It's that it's a woman attracted to a woman, right? If the woman were a man, it would no longer be gay, right? So what are we talking about? I don't understand. All right. Anyways, let's do some other cases while we try to figure out what the confusion was. So let's abandon that talk and go into something else. Let's start with the Nuclear Regulatory Commission versus Texas, coming out of the Fifth Circuit, because that's where the Texas is. The Atomic Energy Act of 1954 generally prohibits private possession of nuclear materials. So you're saying that I need to give the uranium back? Aww. Without a license, including spent nuclear fuel without a license. The Nuclear Regulatory Commission may license the possession of nuclear materials subject to statutory and procedural requirements. Here, Interim Storage Partners applied for a license to build a facility in West Texas to store the spent nuclear fuel. During the licensing proceeding, a Texas governmental agency submitted comments, including comments on a draft environmental impact statement prepared by the Commission for the proposed faculty. Fasken Land and Minerals, a private West Texas business, similarly submitted comments and also sought to intervene. The Commission denied the petition intervene. He then unsuccessfully challenged that denial of intervention before the Commission. In September 2021, the Commission granted the company a license to build and operate the storage facility. Texas and Fasken sought to review the Commission's licensing decision. The Fifth Circuit vacated the license. Okay. Held. Because Texas and Fasken were not parties to the Commission's licensing procedures, they're not entitled to obtain judicial review of the licensing decision. Okay, so this is just straight up a standing question, I guess. So like, who has the ability to challenge the licensing decision? And because you're not a party, you can't challenge the decision. Okay, I mean, that makes sense to me, right? So yeah, I understand. And apparently this was consolidated with some other case. Anyways, in the Hobbs Act, Congress specified that only a party aggrieved by the licensing order may seek judicial review. Texas and Fasken argue they qualify as parties because they participate in the licensing proceeding. That is not even close to how that works. By submitting comments on the draft proposal, and in Fasken's case, by attempting to intervene. Well, he failed. But the text of the Atomic Energy Act indicates that one must be licensed, applicant, or successfully intervene in order to obtain party status. Well, no shit. The Act provides that the Commission shall grant a hearing upon the request of any person whose interests may be affected by the proceeding and shall admit any such person to the proceeding. So if there's a third party that's implicated by it in some way directly, then they can intervene. And that's not like a foreign concept in law. That's like if I'm suing somebody, there might be a third party that's also relevant. This would be the most often way that would be true would be if the defendant themselves wanted to bring in a third party because the third party is partially responsible. Say I'm suing somebody for whatever, and that person believes that another person is wholly or partially responsible. What they can do is called impleading them. So they can bring them into the lawsuit themselves because like, well, you know, I'm not suffering this alone. Or another person can intervene in a lawsuit in similar circumstances if it would affect their rights, and particularly if redress could not be granted once the case is disposed of. So let's suppose I'm a third party that also has an interest in it. If my interests can be satisfied after the lawsuit is complete, then I can be invited in. If they can only be done in this lawsuit, then I must be allowed in. I'm trying to think of a hypothetical off the top of my head. Let's suppose, I don't know, let's suppose we're arguing over a unique piece of personal property. Okay, we'll make it a unique piece of personal property. We're arguing over, let's say, the original Batmobile. I don't know, who cares? We're arguing over the original Batmobile, and I think that I own the Batmobile, and another person thinks they own the Batmobile, and a third person thinks they own the Batmobile, right? So some guy has possession of the Batmobile. Another guy thinks he owns it, so he sues the other guy, okay? He sues the other guy, and for whatever reason, he's made clear that if he wins, he wants to destroy the Batmobile. I don't know why he wants to do this, but he just does. He thinks he owns it, and he also he thinks it's too good for this world. So he wants to destroy it. So if he wins, he's going to get the Batmobile and he's going to destroy it. Let's suppose I also think that I own it. Well, if he wins and he destroys the Batmobile, then I can't really get redress because this is a unique item, right? So I can't really be made whole. So I need to be able to get involved in this lawsuit so I can adjudicate my interests. That's probably the worst example I've ever come up with off the back of my head, but it's what I came up with this morning, and that's what we're doing. It's not an amicus, because an amicus is not a party. An amicus is someone who has musings on the law for the potential benefit of one of the other parties. An amicus has no interest. An amicus has no interest, at least directly. Their interest is in the law, not in the things that are in dispute. So this would be someone who has an interest in the items in dispute. It could be real estate, it could be personal property, but they have an interest in the item or items itself. Yeah. In any case, let's press on. All right. That means a person becomes a party only after the person requests to participate in the hearing before the commission that has requested to intervene and is actually admitted to the proceeding. And if the commission fails to admit someone, that is not a party. Fasken contends it can maintain the suit because it satisfies the statutory criteria for intervention under the Atomic Energy Act, and the commission erroneously denied its intervention. Fasken also argues the commission intervention regulations set a high bar for intervention that the Atomic Energy contemplates. But Fasken could and already did obtain judicial review in the DC Circuit of its petition. Yeah, so like you can say I should have been brought into this lawsuit, but we've already had that fight, so that's over. In the DC Circuit, Fasken did not question the legality of the commission's intervention regulations. Fasken simply challenged how the commission applied its regulations. But the DC Circuit rejected the arguments and upheld the commission's denial of the petition. And Fasken did not seek en banc review or cert. So that issue's decided. So you tried, you failed, you appealed, you lost, that's over. Res judicata, suck it. Yeah, Travis says, for CLE reporting purposes, my bar number is, right? No joke, Travis. No joke. I really should be giving out CLE credit. Although if the bar saw this, they would probably object because I don't have the right temperament or some bullshit. Blah, blah, blah. The bar is not happy, fun people. The bar does not know how to party, notwithstanding their name. The bar sucks. All right, let's press on. Decision on intervention is final. Well, yeah, because you appealed and you appealed and you didn't further appeal, so of course it's final. Fasken cannot now use the Hobbs Act to collaterally sue. Yeah, not so much. No, that's over. Texas and Fasken alternatively argue they need not be parties to challenge this ultra virus action. Ultra virus just means without power. Because the ultra virus review could easily be circumvent judicial review status, this court's cases have strictly limited non-statutory ultra virus review. Fair. The court's leading case on ultra virus review is Limden versus Kine, holding that non-statutory review is available because an agency order was attempted exercise of power that has been specifically withheld and violated a specific prohibition. So you want to sue the government because they don't have power. Well, if we allowed those lawsuits, they would like happen all the time. So that sounds dumb. So we're not just going to allow that for non-parties, right? This is a whole issue of standing. Standing's the fundamental problem, right? You as a third party want to say that the agency lacked power to do something, but they didn't do it to you. So, you know, if anyone could bring that lawsuit, then those lawsuits would be filed all the time, and that would be really dumb. Also, it would be unconstitutional because of Article 3. In any event, we're not going to do that. Sometimes the statute allows for it, which is Congress's prerogative, but unless Congress has said so, we're like, yeah, we're not going to do that. The kind exception is a narrow one that does not apply simply because an agency arbitrarily reached a conclusion was not comport with law. Rather, it applies only when an agency acts in excess of delegated powers and contrary to a specific prohibition. Yeah, that's a small door, and we're not widening it, says the Supreme Court. I'm feeling that. For at least two reasons, Texas and Fasken's ultra vires claims fall short. First, Texas and Fasken basically dress up a typical statutory authority argument as ultra vires. Of course they did, right? Yeah, they dressed up, we think that you didn't obey the statute with, this is totally beyond your power and beyond the pale. And, you know, they tried to elevate it because they wanted to make it seem big, but, you know, we're not fooled by you. You know, you might be trying to make your coat and make yourself look big, but we're not actually fooled. Yeah. Secondly, ultra vires review is unavailable when the statutory scheme provides aggravated persons with an adequate opportunity. So, first of all, there was a mechanism, and second of all, just still no. Here, entities like Texas and Fasken seeking intervention are granted judicial review of either the commission's intervening denial or interventions granted to file a licensing order. Additionally, no precedent supports bringing ultra vires in a court of appeals rather than in the district court. Yeah, that's good. Let's bring in this new cause of action for the first time at the Court of Appeals. Oh yeah, that's definitely going to be a thing. That's definitely going to work. Sure. Good luck with that plan. Because Texas and Fasken have no right to judicial review of licensing proceedings, the court today does not decide whether the commission possessed the statutory authority because you literally don't have standing and we can't be bothered to care. Kavanaugh delivered the opinion of the court in which Gorsuch, Thomas, and Alito dissent in a 6-3 decision. Sounds right on its surface, and I don't really care enough about the issue to dig into the dissent, despite the fact I'm a Texas fanboy or a Gorsuch fanboy. So we will let it sit and not do that. All right, let's see what else we got today on the docket in Supreme Court land. All right, we turn our attention to the case of EPA versus Clement Shreveport Refining. Okay. The Clean Air Act establishes a comprehensive venue framework for judicial review. Venue is just like literally where are we going to hear this thing? And there are 94 districts in the United States, 94 federal districts. And so one of the things Congress could be concerned about and probably should be concerned about more, to be honest, is where can this lawsuit be filed? Because we're a little bit concerned that maybe you'll just pick your favorite district, which was a problem in patent law until the Supreme Court kicked it in the nuts a couple years ago. All the people wanted to go to the Eastern District of Texas because the Eastern District of Texas basically decided 100% of the time for the patent holder. So if you're the patent holder, the Eastern District of Texas was great. So they always sued in the Eastern District of Texas because they always won. It's like, well, you know, good for you, but, you know, so the Supreme Court kind of nipped that in the bud. And that's one of the things they're concerned about. And the Clean Air Act has some language on this point because Congress tried to think this one ahead. That's nice. Under the relevant law, nationally applicable EPA actions must be challenged exclusively in the DC circuit, while locally or regionally applicable actions ordinarily belong in the regional circuits. Okay. However, local or regional appealable actions that are based on a determination of a nationwide scope or fact must be reviewed in the DC circuit if EPA finds and publishes that such basis exists. Does that mean that in those circumstances, we could hypothetically go from like Texas to the DC Court of Appeals? Because that'd be kind of cool. right? Normally, you don't really allow for that thing. Normally, if you're appealing a Texas case, normally you wind up in the Fifth Circuit Court of Appeals. Now, if you're a patent case in Texas, you wind up in the Court of Appeals for the Federal Circuit because that's why they're there, right? You are a district court. You're dealing a patent case. Are you going to the Fifth Circuit? Nope. You're not going to the Fifth Circuit. You're going to the Federal Circuit. So that'd be interesting. Is that meant to imply that in some situations I could be in Texas and my appeal is in the DC Circuit? Because that'd be kind of cool. Just like procedurally, that'd be cool. I mean, you know. In any event, this tripartite system reflects congressional intent to challenge nationally significant EP actions to DC action while keeping most of the regional actions located in local circuits. I think it does mean that. I think that's exactly what it means. Under the CAA's renewable fuel program, most domestic refineries must blend specific amounts of ethanol and other renewable fuels into transportation fuels they produce. That could lead to some very interesting things. That would make things very interesting for our practitioners at the district court level. Because now if I bring an EPA action, say in Texas, right? Which circuit or circuits provide binding precedential authority is now a question I'm now suddenly asking, right? Because if regional cases go to the regional circuit and national cases go to DC circuit, if I'm a trial lawyer in the Eastern District of Texas with an EPA case, I suddenly am now asking the question, is this Fifth Circuit precedent binding? Is this DC Circuit precedent binding? That's fun. That's fun. Yeah, I have to figure out which circuit's precedents are now binding. That's great. That's fun. What if the Fifth Circuit precedent and the DC Circuit precedent conflict? The challenges for the practitioner become more and more lucid with every moment. This is fun and exciting. At least my bills get to go up as I try to figure out what circuit's laws apply. This is great. All right, under the CAA's renewable fuel program, most domestic refineries must blend a specific amount of ethanol and other renewable fuels into transportation fuels they provide. How do I feel about the syllabus authors? I'm always happy with the syllabus. Yeah, the syllabus always seems clean to me. I've never had a problem with it in recent memory. The Act provides a phased exemption scheme for small refineries, those possessing no more than 75,000 barrels of crude oil daily, allowing them to petition the EPA for exemptions based on disproportionate economic hardship. Following this court's decision in Holly Frontier, which clarified that small refineries could obtain exemption exceptions even after their original exemptions had lapsed, the DC Circuit remanded pending exemptions for reconsideration. EPA then proposed and ultimately denied 105 small refinery exemption petitions and 2 omnibus notices issued in April and July of 2022. EPA denials were based on 2 principal determinations. First, its interpretation that disproportionate economic hardship covers only hardship directly caused by the renewable program compliance. Okay, I mean, that's an interesting take that's not necessarily inherently obvious, that compliance with the program itself is the thing that's causing hardship as opposed to you just have hardship in general. So if you have hardship in general, but the compliance with this program doesn't cause it, then I guess you're just out of luck. That's an interesting interpretation. And second, it's economic theory that renewable identification number costs are fully passed through to consumers, creating a presumption against granting exemptions. EPA applied these determinations uniformly while conducting confirmatory reviews of individual refineries. EPA asserted in its denial notices that denials were reviewable only in the DC Circuit, either as nationally applicable actions or, in the alternative, as locally applicable actions based on determination. So we're actually having a fight over which court of appeals this goes to. Epic, right? That's great. Which court of appeals is going to hear this case? Fun. That's great. Smaller refineries challenge these denials in multiple regional circuits. Most circuits either did not dismiss the challenge for improper venue or transfer them. However, the Fifth Circuit retained jurisdiction. Yeah, that's great. So we've got both the DC Circuit and the Fifth Circuit saying, I'm the Court of Appeals. That's fantastic. Both the DC Circuit and the Fifth Circuit raised their hands saying, I'm the Court of Appeals. Great. However, the Fifth Circuit retained jurisdiction, rejecting EPA's venue argument and ruling for refineries on the merits. The Fifth Circuit reasoned that EPA's actions were merely locally applicable because their legal effect was limited to the petitioning refineries, and the actions were not based on determinations of nationwide scope or effect because EPA still examined refinery specifics. Okay, so which Court of Appeals is correct Court of Appeals? All right, let's go on. Held. EPA's denial of small refinery exemptions petitions are locally or regionally applicable actions that fall within a nationwide scope exception requiring the DC Circuit. Okay. The relevant law creates a two-step inquiry for determining venue. First, courts assess whether the EPA action is nationally applicable or only locally or regionally applicable. If nationally applicable, the case belongs to DC Circuit. If local or regionally applicable, courts proceed to the second step to determine whether the nationwide scope or effect applies to the overall default rule of the regional circuit review. To identify the relevant action, court must look to authorizing CAA provisions rather than how the EPA packages the decision. The enumerated actions make clear that this provision treats each activity the Clean Air Act allows the EPA to take as a distinct action. Because the relevant law allows a small refinery to petition the EPA for extension of its exemption and requires EPA to act on any petition submitted, each EPA denial of refinery exemption petitions constitutes its own action for venue purposes. I mean, it would have to, right? Because every single thing is a discrete action, right? They're all separate refineries. They're all asking for exemptions. The EPA is considering them all independently. They're all providing them independent decisions. So each action would, of course, be independent. I mean, there's no alternative. An action is nationally applicable if it applies on its face throughout the entire country, or only local or regionally applicable if it applies only to particular localities or regions. EPA's denial of a single refinery exemption petition applies only to that refinery, a particular entity in a particular place, making such denials pragmatically local or regional. Yes, in the first instance, of course they are, right? Because the refinery exists in a place. It's a building that exists somewhere, right? So, I mean, the refinery is not the size of the nation. So the initial decision will obviously be local because the refinery is obviously local because it exists somewhere, like geographically. I mean, that makes sense. All right, moving on. The EPA's argument it can control the unit of action for venue purposes. Oh my God, it's Chevron all over again. Please don't do this to me. The EPA is arguing they can aggregate them. This is just the same argument in Chevron. All right, fine. The EPA's argument can control the unit of action for venue purposes by aggregating smaller petition in omnibus notices, lacks any statutory limiting principle, and will effectively give EPA veto power over venue. EPA's position that any action affecting more than one circuit is nationally applicable will render actions with plainly local or national effects simply because their locality straddles the circuit lines. Oh, thank God we're not allowing the aggregation. Oh, thank God we're not doing that again. No, thank God. I can't. I don't want to play anymore. No, EPA, you can't do that. Okay, just because you made a note. So normally you have 100 refineries who have petitioned you. And if you made 100 separate decisions, they're obviously separate. So what you thought to yourself is what we're going to do is rather than issue 100 separate decisions, what we're going to do is effectively consolidate them. And we're going to put them into one big, beautiful decision. The one big, beautiful decision. And it's an omnibus notice. And therefore, it now becomes national because these 100 refineries are all over the place. And the Supreme Court's like, no, we fell for that trick. We fell for that trick 40 years ago. We're not falling for that trick again. No aggregation for you. Go to hell. Thank God. Because EPA actions are local or regionally applicable, the court must determine whether the nationwide scope or effect exemption applies. This exemption requires that the action is based on determination of nationwide scope or effect, and the EPA finds and publishes that such action is based on a determination. All agree the second requirement is satisfied. A determination refers to, there's a lot of uranium in Texas. Can I just go to the uranium mine and get myself some uranium? I'm gonna go down to come down to Billy's uranium mine. Come down to Big Billy's uranium mine. We got the best uranium ever. We got big uranium, a small uranium, 235, 238. We got all the uranium you want. You get to pick it yourself. We got yellow cake. We got blue cake. We got orange cake. We got red cake. We got all the cakes you need. Cake for days. Come down this Sunday for our 2-to-1 offer. A determination refers to EPA's justification in taking the action. Determinations are nationwide scope if they apply throughout the country as a legal matter de jure, and nationwide effect if they so apply as a practical matter de facto. An EPA action is based on determination of nationwide scope or effect only if the determination lies at the core of the agency action and forms the primary explanation for and driver of the action. This requires more than but-for causation. It requires justification of nationwide breadth, the most important part of the EPA reasoning. Yeah, also, does Big Billy's Refinery also sell centrifuges? Asking for a friend. No particular reason. I need about 40,000. Applying this framework, EPA's exemption denials were based on determination of nationwide scope or effect. EPA's interpretation of disproportionate economic hardship under the relevant law and its pass-through theory are clear determinations of nationwide scope or effect that applies generically to all refineries, regardless of geographic location. These determinations form the core basis for EPA's denials because EPA used them to reach a presumptive resolution to deny all petitions, then considered refinery factors only to confirm it had no reason to depart from the presumptive deposition or disposition. Where the EPA relies on determination, nationwide scope, or effect to reach a presumptive resolution, these determinations qualify as primary driver's decisions. The confirmatory review of refinery facts is merely peripheral. So basically, if the reason we're denying it is because we have a universal standard, then the universal standard is national, right? So although each refinery is being evaluated separately, the question is, what is the criteria, right? So if we have a big master list of criteria, right, that we apply everywhere, right, then that's national. Like the determination is individual, but the rule is global, right? And that sort of makes sense. And the EPA could have non-global rules. They could do that, right? They could, for whatever combination of reasons, have different rules in different parts of the country, which might be perfectly legitimate based on various concerns. So the question is, are we applying like national rules? Or are we applying local rules or regional rules? And so that's what we're going to break this on, not whether the decision is individual or collective, but whether the rule is individual or collective. I'm like, okay, that makes more sense. I get that. That's fine. That makes fine to me. The court rejects EPA's argument determination covers only the resolution of unsettled issues, as well as respondents' argument that determination is a term of art applicable only when the provision textually directs EPA to make determination for the entire nation. The court also rejects the argument that EPA consideration of refinery-specific facts precludes the exceptions application, noting that the exemption requires an action be based on, not based solely on, the nationwide impact. I'm fine with all that, right? So obviously the facts are fact-specific because every refinery is different and what they're trying to do is different. So it's fact-specific, but that doesn't mean the rule is not global, right? The rule is just the rule. So the rule is just applies to everybody. Your facts, how they break for you is however they break for you, but the rule is global. So the fact that we did some sort of determination is just due process, not not anything else. So yeah, that's fine by me. Thomas delivered the opinion of the court. Gorsuch dissents with Roberts in a 7-2. Gorsuch apparently dissenting today, I guess. But I have no problem with that. That sounds fine to me. All right, how are you guys doing in chat? You guys having fun? There's 551 of you here, which is actually pretty good for a Supreme Court stream. So I guess you guys are having fun, which is good for me. How you guys feeling? I miss Spinny Fan. Not gonna lie. I wonder if there's a Spinny Fan thing I can add to my my thing behind me. So let's see if there's a Spinny Fan GIF I can add that I can put behind me. So Spinny Fan will from time to time appear. Let's see what we got. All right. There's some options. They're not the same. Is there any one of them that's like any good? I guess I'll do this one. All right. Is the EPA abolished? No. The EPA is not abolished. No. All right. Oh, was there two decisions that did the exact same thing? All right, there was another decision that was like on a very similar issue, so I was confused for a second because it's very, very similar. All right, let's do this other one. All right. We turn our attention to Oklahoma versus EPA. The Clean Air Act channels challenges to the EPA's action to the U.S. Court of Appeals for D.C. Circuit if they're nationally applicable, and the regional circuits if they're local or regionally applicable. The relevant law contains an exception for locally or regionally applicable actions based on determination of nationwide scope of effect, which also must be brought to the D.C. Circuit. In 2015, EPA revised the National Ambient Air Quality Standards for ozone to be more stringent. Each state submitted a state implementation plan detailing how it would comply with the CAA's Good Neighbor provision, which requires them to contain adequate provisions prohibiting in-state emissions activity that would interfere with other states' compliance. EPA ultimately disapproved 21 states' plans for failure to comply with the Good Neighbor provisions. These states asserts that they did not need to propose new emission reduction measures, but the EPA disagreed after considering the contents of each state's submission on its merits and making individual determinations for each plan. The EPA aggregated its disapprovals into one omnibus, describing the EPA's four-step framework for evaluating the submissions. EPA asserted in a rule that disapprovals would be reviewable only to the DC Circuit as they are nationally applicable actions, or alternatively, as local or regional applicable actions falling within nationwide scope and effect, based on EPA's use of the same nationally consistent four-step framework and its evaluation for national consistency. State and industry petitions challenged the EPA's disapprovals in regional circuits. Of 5 circuits to resolve EPA's motions to dismiss or transfer, 4 found the regional circuit review proper. Only the 10th Circuit disagreed, granting the EPA's motion to transfer suits by Oklahoma and Utah. The 10th Circuit concluded that EPA's omnibus rule constituted a single nationally applicable action because it covered 21 states across the country and reflected EPA's application of uniform statutory interpretation. Held, EPA's disapprovals of Oklahoma and Utah are local or regionally applicable actions reviewable in the regional circuit. Okay, so we have to figure, so this is a very similar issue that goes the other way. So we have to understand how these rules work together. Hello, Karen, or my cat's name is Karen. EPA approvals of Oklahoma and, all right, we read that. Applying the framework of EPA versus Shreveport, which we literally just decided 5 seconds ago, Venue determination requires a two-step inquiry. First, courts identify the relevant EPA action and ask whether it's nationally applicable or only regionally applicable. If nationally applicable, challenges are brought to the DC Circuit. If locally or regionally applicable, courts proceed to the second step. You know what's also interesting about this is that I just learned that there are other cases which go to one circuit like that. I obviously knew that was true for patent cases, but I didn't know there were other cases like that. So this is, you get to learn something, right? I didn't know that in some other situations, there is a singular court of appeals. That's fun to learn. It's always fun to learn something new, right? Any action under the relevant laws, particular exercise of EPA authority. Should I join the DC circuit? Probably should. I should probably join the DC bar for no other reason than there's no CLE, but I still would have to pay membership dues, which is annoying. Maybe I should join the DC Court of Appeals or DC Circuit or DC, and then I should let my Virginia membership lapse or something. I don't know, something to think about for the future. Courts determine relevant action by reference to CAA's provision under which the EPA acted, not how the EPA presented its decision. Is there a TMZ juror interview? Is there really a juror interview on TMZ? Lord have mercy. Relevant law enumerates, is it any good? Does it go on for any long? How long is it? The relevant law enumerates an individual's approval as an example of local or regionally applicable action, referring explicitly to EPA's action approving an implementation plan. It follows that each approval is also its own action since each EPA undertakes their disapprovals pursuant to the same authority. The relevant law directs each state to adopt and submit a plan and directs it either approve or disapprove. Thus, EPA's approvals and disapprovals are opposite sides of the same coin. The two disapprovals here are undisputably locally or regional. Not long, that's good. All right, after this is over, we'll watch it together. That'll be fun. The two disapprovals here are undisputably local or regionally applicable actions. An SIP is a state-specific plan, so the EPA's disapproval on its face applies only to the state that proposed it. An EPA decision on individual is prototypically local. Okay. EPA in the 10th Circuit contrary argument fails. The relevant law makes the CAA framing of the relevant action controlling, regardless of how EPA packages it. Although EPA is free to aggregate its disapprovals into one rule, the aggregation has no significance. 10th Circuit viewed that the action is whatever it chooses to issue, fails to grapple with what it means by action, which is defined reference to the underlying action, not the stylization. The 10th Circuit also erred in determining them nationally applicable based on the uniform standards of interpretation and common analytical methods. The applicability of the action turns on its formal geographic scope. An action applies nationally only on its face is binding effect throughout the country. EPA's interpretive analytical methodology goes with underlying reasoning, which matters only at the second step. Okay. Because EPA disapprovals are local or regionally applicable, the court must determine whether the nationwide scope or effect exception applies. This exception requires that the action is based on determination of a nationwide scope or effect, and EPA finds and publishes the action based on the determination. The second requirement is satisfied because the EPA included express finding in the notice. The court holds that disapprovals were not based on any determination of nationwide scope and effect. The requirement is met only if a justification of nationwide breadth is the primary explanation for and driver of the action. Such a justification does not rise to this level if EPA also relied in significant part on intensely factual considerations. I don't know. I'm having a tough time squaring this with the last decision. This is I'm confused. Yeah, I'm having a tough time squaring this one with the last one. Okay. So it's not, if it's really factually based, then if it's really factually based, it suddenly becomes local again. Okay. EPA, how are you supposed to make that determination? EPA Omnibus Rule makes it clear that the disapprovals were based on a number of intensely factual determinations, particular to each state. What? The EPA evaluated the contents of each thing on its own merits, concerning state-specific facts and the information available to the state. From the state-specific analysis, EPA produced for each state a unique list of bases for disapproval. Okay. For Oklahoma, EPA rejected its attempt to disclaim responsibility for certain emissions in Texas and faulted it for insufficient evaluation for additional emissions of control opportunities. Well, if I'm a district judge reading these two syllabuses, my first thought is, well, fuck me. No matter what I'm going to do, I'm going to get it wrong. I'm going to get wrong no matter what I do. For Utah, EPA found inadequate justification for Utah's attempt to discount certain emissions in Colorado, as well as technical and legal flaws in the state's argument regarding various emissions considerations. This state-specific analysis contrasts sharply with EPA's justification in Calmu, where an EPA made the determination that applied uniformly to all small refineries and then used them to reach a presumptive conclusion, considering refinery-specific facts only to confirm there's no reason to depart. Here, there's no nationwide factor that settles the decision. Instead, the EPA disapproved after conducting predominantly fact-specific analysis. So if I use some facts, it's okay. But if I use a lot of facts, that's different. Right? Not sure how I'm supposed to do that, but okay. I'm not going to get this right. I'm just going to roll the magic 8 ball. I'm going to make a decision, and I'm just going to be comfortable with the fact that I'm going to get overruled. I'm just like, just appeal. Just appeal. I know I'm wrong. I just don't know why I'm wrong. Just appeal. The four determinative EPA proffers use updated 2016 base modeling, application of the 1% contribution threshold, determination that other states' contributions could not excuse analyzing whether their own emissions significantly contribute downwind. Yeah, not for at least the reasons that, as I said, like as the district court, I'm now also faced with the task of which circuit precedent is binding, right? Because the determination of whether it's local or national determines which circuit's precedent is binding. So how am I supposed to, as the district court, how am I supposed to know which circuit's law to apply? Jesus Christ. The four determinations EPA proffers: use of updated 2016 base modeling, application 1% threshold, determination other state contributions could not excuse analyzing whether their own emissions significantly contributed downwind, and its position that states cannot rely on emissions reduction measures, non-incorporated other state plans, qualifies determination nationwide scope. But these conclusions are at most heuristics that aid EPA's analysis rather than primary drivers of disapproval. What? None make clear why EPA conclude that Utah and Oklahoma have produced inadequate proposals for good neighbor compliance. Commerce delivers the opinion of the court in an 8-0 unanimous decision, I guess. And I'm not sure what it says. Well, all right. Let's do this interview thing. I'd have to read both decisions in full, but based on the syllabus, I have no idea what I'm supposed to do. I don't know what you want me to do. Oh, Lord. All right, let's see what this thing is. All right, this is 10 minutes long. This is interesting. Let's watch this for a while. The jury found... change the audio source.
Karen Reed.
Why? No, I changed it. Hey, that's not fair. I changed it. You're supposed to change it when I change it. That's not nice.
Not guilty on murder and manslaughter. Was it because they had reasonable doubt or because they thought she was innocent?
So I think for the jurors, there's a mix of some people think that she was definitely innocent, and the other people, there was a lot of reasonable doubt, at least to where we didn't want to convict her.
That's really interesting. So could you give me a breakdown there? Roughly what percentage of the jury felt she was innocent?
I mean, I can only speak for myself. I think that she was innocent. It's hard to tell exactly what people think deep down. There was a lot of things thrown at us, evidence. So it's hard to tell what truly.
So you say in your head she was innocent. Does that mean you think she was framed by people inside that house?
It doesn't necessarily mean that. I don't know what happened. I don't know what happened to John.
Fair.
Really, I was only presented a limited scope of what happened at the night, and I could only base my opinion off of the evidence that was shown in the courtroom. So
fair enough.
I don't really know if there was a cover-up or not. I know that's the big conspiracy around it, but I don't really know. All I know is that there was a lot of holes in the investigation.
There you go. Fair enough.
Deliberate holes or not deliberate holes, it's kind of hard from me sitting back to know that, what actually happened.
So what was the feeling of the jury? Because Alan Jackson and the other lawyers raised the issue that she was framed by cops and that they would have turned that house upside down if they really wanted to do an honest investigation, and that he was not hit by a car. He was attacked in that house, bitten by a dog, and then put outside to frame her. Did people on the jury, or some of them, buy that argument?
I think some of them bought that argument. It's just hard to tell, though, because whether or not we think that there was malicious intent, we were only presented with the facts that they didn't go into the house. So,
yep, there you go.
There's an example of reasonable doubt. So, there's other examples of reasonable doubt. So even if you want to completely buy into the theory or not, that wasn't what we were tasked with. We were tasked with finding, convicting, or deciding on this person's fate based on the proof and the evidence that the Commonwealth was able to present. And there was a lot of holes in the investigation.
This guy sounds like he kind of understood the assignment. I'm having a lot better feeling about this guy than Jury Ronnie. This guy sounds like he kind of understood the assignment. Yeah, I don't know, man. I don't know what really happened. I wasn't presented with evidence. I don't know, man. All I know is that, what I was presented with was kind of shit. Didn't do it for me. Don't really know what happened. Don't have enough information. What I do know is what I was shown as shit. Respect, you, juror. It sounds like you understood the assignment. Good job.
Yet you went many steps beyond that because you say, in your view, she was innocent. What compels you to think that?
Well, one thing that I think that compels me is we did a lot of review of the tapes, and it seemed to me that the videos that we could see from the car after the alleged incident happened, that when we could see the taillight, it was lit up red where it shouldn't just have been red. So that leaves to me a conclusion of, well, how come it's red in this video after the alleged, collision happened?
That's a pretty good question.
And it's, it's not, it doesn't have any red pieces where it should be red.
Did you consider unexpected black hole? Did you consider that possibility? That's the reason it appeared red, because of unexpected black hole. Did you consider that idea? No? Oh, well.
So in other words, you do not believe that SUV made contact with John O'Keefe?
I don't believe that the SUV collided with John O'Keefe.
What was the initial vote with the...
Well, that kind of does it for you, right? If you don't think the collision happened, it's kind of like, yeah, we're done. That's like, yeah, that's, we can stop talking. Yeah, that works. Yeah, that's great. Good job.
The jury, when you first took your vote?
We didn't do an initial straw poll. The judge recommended to us in the courtroom that is not a good way to do it. We broke down what we did is we broke down each charge, and we went from top to bottom and discussed everything thoroughly, and did our best to do right by the Karen Reed and the Commonwealth.
Was there a division initially?
Yeah, there was a division.
You want to clarify that?
That's what we're there to deliberate and talk about all the evidence. There was 2 months of us sitting there, them throwing all this information at us absorbing the information, going home, thinking about it, reviewing it in our heads, and we get to the deliberations, and now we have an opportunity to discuss. Some people went into the deliberations and they were still unsure after two months, and that makes sense because there was a lot of things going on. There's a lot of information. How much can you weigh one thing or another thing over,
Yeah. What about jurors who felt initially she was guilty? Were there any of them?
Yeah, there were a few jurors that think that had thought that initially when they went into the deliberations, that was their standpoint, and that's what we were there to do, to talk through all that and bring up every single piece of evidence. Is there an angle of reasonable doubt to where we're not really sure? Like, are you really sure? Are you 100%, or are you 99.9%? If you're that 99%, we can't convict you.
Well, you really can. I mean, 99%. I mean, if you ask most lawyers what reasonable doubt is, like 95 to 99% is usually what we will say, or, maybe a little bit higher than that. But yeah, if you're 99% sure, 99% will do. But he wanted 100%. So, okay, fair enough, I guess. Yeah. All right.
What brought the ones who felt she was guilty over to the not guilty side? Was there anything in particular that seemed to resonate with them?
It's hard to tell from my position. You'd have to ask them about it. But in my opinion, I think it was just due to the poor investigation. There's just too many holes. And, it's hard to prove that the collision happened. So if there's reasonable doubt that happened, or that there may have been foul play, if there's room for that, then it's hard to come to a guilty verdict.
What happened when the jury initially said they had a verdict and then said, oops, no, we don't, and then 15 minutes later they said, oh, we do? What happened there?
That actually is kind of interesting. So the envelope, it was sealed and it's locked away. It'll never be looked at. But on everything on that initial slip was the same as the slip that was presented.
I believe it.
But why did they pull it back?
The pulling the back was for the OUI charge.
Driving under the influence, essentially, drunk driving.
Yes, driving under the influence. We in our deliberations, we had decided there was enough evidence and proof that she was driving under the influence.
So, how did the defense do? How did the lawyers do, in your view? Her lawyers.
For her lawyers specifically, I think they all did. I think that all the lawyers on both sides did a really good job.
Really? Well, I suppose it depends what you mean by a really good job. There are ways to view what Brennan did as being very good, if morally bankrupt. But all right, fair enough. All right.
They presented their case as well.
The police, you say the investigation was poor. The defense said it was more than poor. It was corrupt, and they pointed to the lead detective who had been fired, didn't testify in your trial. Did that have an impact? And did you think it was a corrupt police investigation?
Do I think it was a corrupt police investigation? I don't know. There's
job.
no way for me to know. I wasn't there. There was just, there was holes in the case that left for reasonable doubt.
Yeah.
They could have checked some boxes or, you know, done some things differently. But do I know that they were corrupt? Absolutely not.
Respect. Not my circus, not my monkeys. Not my circus, not my monkeys. Not my job. Was it corrupt? Don't know. Don't care. Not my problem. All I know is that it was shit. They gave me shit. That's all I know. I don't know why it was shit. And frankly, I don't care. All I need to know is that it's shit. Fantastic. This guy sounds like he understands the assignment. This guy's doing great.
I don't know that there was any corruption going on, but do I know that there wasn't enough proof or evidence secured by the police to convict Karen Reed? Absolutely.
Yep, there you go.
There was not.
That's all you need to know. That is all you need to know. Do I know it's corrupt? No. Do I know it wasn't enough? You bet your ass. Great. Good job. Fantastic. More jurors like you. If we had more jurors like you, we'd be doing fine, man. Also, do you want to be a judge? Because I think you do a better job at this point.
To say that your view was that her SUV did not make contact with O'Keefe, therefore she did not kill him, but you don't know how he died.
I would say that's fair to say. I don't know how John O'Keefe died.
Yeah.
I do not believe that there was a collision between the SUV.
There you
and John
go.
O'Keefe.
Very good. Did all of the...
I don't know how he died. I do know how he didn't die. Yeah, there you go. I don't know how he died, but I do know how he didn't die. Fantastic. Great job. You understood fantastically.
The hoopla around the case, the people outside, did it give you comfort in reaching a verdict like this that you saw there was a community behind your point of view, or was it irrelevant?
Honestly, that made the pressure a lot harder, and it did not give me comfort. It made it.
How did Judge Cannoni let this one slip through? That's the only question I want to know the answer to right now. How did Judge Cannoni allow this juror to actually wind up sitting on the jury? Tisk, 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 man. Tisk, 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 man. I thought you were better than this.
It a lot harder to block out everything and come to a decision.
Why did it make it harder?
It made it harder because all of the eyes are on us. We were told we're the most important people in the courtroom, and you know they keep us away from the crowds of people in the front of the courthouse, but we do see them, and I don't think that having all those people swayed me to go either way. We were only tasked with looking at the evidence. We have to
respect
12 jurors. We had to back up how we felt in this, for our decision, and we couldn't let any outside factors, her punishment. We couldn't factor any of that. We had to look at the evidence that was presented to us.
Wow, you actually did your fucking job.
Really
amazing.
Understand it, and see if there's any reasonable doubt, and there was.
That guy's great. I like this guy very much. This guy gives me hope. This guy's great. He gives me hope. You know, he's doing pretty good. He's doing pretty good. You know, we could quibble, we could quibble, but you know, for his first time around, I think he's doing pretty good, man. He's most of the way there. He's most of the way there. He understands the assignment. It's like, not my job, not my monkeys, not my problem. All I know is is that the vehicle didn't hit him. Cool. Right? And if it were me, I'd be like, well, all I know is that assuming the collision happened, it didn't lead to the death. Right? So I'd break it in a different point. But what do you care? Right? What do you care what my reasonable doubt is? As long as there is one, right? It's like, oh, he says he thinks the collision didn't happen. I'm like, well, maybe it happened, but it didn't lead to the death. But we each have a reasonable doubt. So what does it matter, right? As long as you break it in a reasonable doubt, who fuck cares what it is, right? So like, yeah, that's fine. The other thing that I sort of note is he didn't like note exactly what the numbers were or percentages are, like in terms of like how many jurors were guilt or how many were. And it's like, I don't know what the number is near to you because he didn't really seem to indicate. I mean, based on his tone, and I mean, I'm tea leaf reading in his body language, which is dangerous for me because I'm not the best at that. But based on his tone, demeanor, and other things, it seemed to me to suggest that it was like more than one. I got the feeling that we were like talking like 3 to 5, maybe. It was sort of in the range of what it seemed to me he was saying. And if it was something like that, then I think that, depending on the personalities of the people, again, I think the 20% conviction number is still like a pretty good number. Like the 20% chance to convict. It's like, if you assume it was 3 people, just to give a number, right? If you assume it's 3 people, it was 3 to 9 as the first vote, which is one hell of an assumption. But even if you assume that, like if those 3 people are particularly strong-willed and the 9 people are not as strong-willed, man, that could go a different way. You're right. You're not only talking about the intelligence of the people, but their ability to stand up to social pressure, their desire to want to please others, their desire to want to conform to others, their how loud they are and all the rest of it, right? So, fortunately it broke the right way, but like, I think the 20% number is still a pretty good number because it's like, well, I'm basing the probability on jurors believing it, some jurors believing it, and also the probability that those jurors will be convincing jurors. They'll have charisma, they'll be persuasive, they'll be loud, they'll be whatever, right? And the social dynamics. So like, I still think the 20% number was a reasonable prediction based on this fact pattern. And based on what he just told me, it seems like reasonable. So, and I don't know what it took how long it took, how strong. Yeah. And that's like, we still don't know, like how strong were those opinions? Like how long did it take you to convince them? What, was it 5 minutes? Was it 30 minutes? How long did you spend, for example, struggling about what? Right? Did you spend 1 hour talking about murder and then you're like, oh, this is dumb, let's move on to other things? Or did you spend, 16 hours talking about murder before you were like, this is dumb, let's move on to other things? There's a lot more interesting information we could get. So incidentally, by the way, if you're a juror and you'd like to speak to me, I have follow-up questions. So I'd like to know a little bit more about the dynamics of the thing and a little bit more about what was going on and so forth and so on. So all those things, that'd be great. But the jury came out the right way in the end, and thank God for that. Thank God for that. All right, let's see what else we got in Supreme Court land. We did that one yesterday. Let's see what else we got. Prison Litigation Reform Act. Okay. Interesting for prisoners. All right, cool. Let's deal with this case. We turn our attention to Petru versus Richard out of the 6th Circuit. The Prison Litigation Reform Act requires prisoners with complaints about prison conditions to exhaust available grievance procedures before filing a suit in federal court. But exhaustion is not required where a prison administrator threatens individual inmates so as to prevent their use of otherwise proper procedures. Such interference with inmates' pursuit of relief renders the administrative process unavailable, so there is no bar. The question presented is whether a party has a right to a jury trial on the exhaustion question when that dispute is intertwined with the merits of the underlying suit. Okay, interesting. No, because it wouldn't have been something that would have been available as a jury trial at common law. So when you have a right to a jury trial, you have a right to a jury trial for things you had a right to a jury trial for at common law. And so this would not be something, I don't think. So my first thought is no, probably not, because this wasn't something that would be available at common law is my first thought. So probably no is the answer. In this inmate inmate Kylie Richards alleged that Thomas Petru, a prison employee, sexually harassed Richards and other inmates. Richards also alleges that when he attempted to file grievance documents about the abuse, Petru destroyed them and retaliated against him for attempting to file them. Richards sued Petru under 1983 for violating his rights, including the First Amendment right to file a grievance. Petru moves for summary judgment, arguing that plaintiffs have failed to exhaust available grievance procedures. The magistrate judge concluded there was a genuine issue of fact as to whether the plaintiffs were excused from properly exhausting their claims due to interference by Petru, and the issue was appropriate for resolution during an evidentiary hearing. At the hearing, the magistrate judge concluded that Richard's witnesses regarding Petru's alleged destruction of grievance forms lacked credibility. The magistrate judge recommended dismissal without prejudice for failure to exhaust, and district court adopted the recommendation. The Sixth Circuit reversed. It said there was no doubt, the Sixth Circuit's going to be wrong. The Sixth Circuit's reversed. It said there was no doubt the judge may otherwise resolve factual disputes regarding exhaustion under the PLRA, but held the Seventh Amendment requires jury trial when resolution of the exhaustion issue would also resolve a genuine dispute of material fact regarding the merits. The decision conflicts with the Seventh Circuit. Held, parties are entitled to a jury trial on PLA exhaustion. Really? The Supreme Court upheld the Sixth Circuit? Seriously? Wow. I mean, you would have thought they would go against them just because it was the Sixth Circuit. I mean, this is almost a habeas issue. They upheld the Sixth Circuit? Wow. Sixth Circuit got one right? Amazing. Before reaching Richard's argument for why the Seventh Amendment right to a jury trial has been violated, the court must further determine whether construction of PLRA is fairly possible by which the constitutional question may be avoided. Such a construction is possible here. Because the court construes the PLRA to require a jury trial, the court need not address whether it could have otherwise required without violating the Seventh Amendment. So that's another way to solve this problem, right? Which is fair, and I didn't factor that into the equation, right? So Congress can extend the right to a jury trial by statute. I was just going straight to the constitutional question, which was a mistake by me. So I made a mistake. It's like, yeah, the first thing I need to consider is whether the statute itself provides relief, right? Because the right to a jury trial under the Constitution is only for the rights at common law, but Congress can always extend more rights. So the first question I should have asked is, does the statute give a right to a jury trial? Fair point. I've been duly chided by the Supreme Court for jumping ahead in the analysis. All right. PLA exhaustion is a standard affirmative defense subject to usual practice under the Federal Rules of Civil Procedure. The usual practice is a factual dispute regarding legal claims go to the jury, even if it means the judge must let the jury decide questions they ordinarily could resolve on their own. That usual practice matters for interpreting the PLRA because Congress understood to legislate against a background of common law adjudicatory principles. With an exception, the principles will apply except where the statutory purpose is evident. No such contrary purpose is evident. The PLRA is silent on whether judges or juries should resolve exhaustion, and silence is strong evidence the usual practice should be followed. Fair enough. We're just going to decide this under the statute. Okay, cool. At the time the PLRA was understood, it was well understood that factual disputes intertwined with claims that fell under the Seventh Circuit should go to the jury. This court has held in various contexts in the case of intertwinement, district judges should structure their orders of authorization to preserve the right to a jury trial. One prominent line of cases involves suits that contain both legal and equitable claims. Right. Equitable claims are not for a jury. So yeah, fair enough. Ordinarily, judges resolve equitable claims and juries resolve legal claims. In Beacon Theaters, this court held that judges may not resolve equitable claims first, if doing so could prevent legal claims from getting to the jury. In that case, both legal and equitable claims hinged on a common issue of whether there was an antitrust violation. The court emphasized in that situation, judicial discretion is very narrowly limited and must, wherever possible, be exercised to preserve the jury trial. Because resolving the equitable claims could prevent a full jury trial on the legal claims need to be resolved first, or at least independently, right? So I suppose that would be permissible too, although it'd be a little weird, but I guess permissible, right? So either do the legal claims first and then do the equitable claims, or I suppose you can do the equitable claims first, but if they have no effect with respect to the legal claim. So you might be left, in a slightly awkward position, but I think that's possible. So either one would be fine, I suppose. In this case, the parties agree that exhaustion and First Amendment questions depend on common factual issues. And Beacon Theater teaches a trial judge must preserve the jury trial in such a situation. Nothing in the PLRA presents holding the jury trial here. Cases involving subject matter jurisdiction are also instructive. Ordinarily, judges may resolve factual disputes when determining subject matter, but courts may not do so when the factual disputes are intertwined with the merits. In Smethers versus Smith, the court held that judicial authority to dismiss for lack of subject matter jurisdiction is obviously not unlimited, for that would risk summarily dismissing the merits without ordinary instance of trial, including the right to a jury trial. In Land versus Dollar, the court found that Land was the type of case where the question of the merits is dependent on the decision of the merits, and thus how the district court should proceed the decision on the merits. In the decision below, the Sixth Circuit relied on precedent applying land, reasoning that if certain cases must be heard and determined on the merits, even where constitutionally implicated decisions are at play, the result should be the same where the lesser concern on the affirmative defense, such as the PLRA's requirement to exhaustion administrative remedies, implicates the merits of the claim. The court finds this reasoning persuasive. After all, when the PLRA was enacted, many lower courts' decisions and treatises have extended the intertwinement principle to other threshold questions like personal jurisdiction and venue. The court expressed no view today on whether lower courts have been correct to extend the intertwinement principle to these other issues, but simply notes that these cases show that when the PLRA was enacted, the usual practice in federal court across a variety of contexts was to resolve factual disputes that are intertwined with the merits at the merit stage. I mean, fair enough. Like, so to the extent that, you know, the merits and therefore a jury, then you need to let the jury do their job, even if they're intertwined with other issues that are not for a jury, which, you know, fair enough. So, I mean, that sounds fine to me. I'm comfortable with all that. The counter arguments are unpersuasive. Petru argues that Beacon theories is inapplicable, but the argument relies on the questionable assumption that judicial fact findings concerning exhaustion have no estoppel effect in later jury trials. Regardless, even if Petru is correct about estoppel, Beacon theory still applies when judicial resolution might prevent a full jury trial for other reasons. Here, Richards claims it's being dismissed entirely rather than just stopped, and it's usually impossible for prisoners to go back and exhaust, then file suit again, because grievance deadlines will have long since passed. Petru's argument that jury trial conflicts with the PLRA's purpose of conserving resources also fails, because it contemplates that merits claims will be resolved by a jury and is silent about exhaustion. The usual federal court practice in cases of intertwinement is set the common issue to the jury, and nothing suggests Congress intended to depart. Roberts delivers an opinion in which Barrett, Thomas, Alito, and Kavanaugh joins in a 5-4 decision, which I understand the dispute immediately. I understand exactly why this is 5-4, because they are trying to infer something from the statute rather than the statute saying it outright, right? They're trying to infer that what Congress meant. They're trying to read into the statute, right, some background principles. And so basically 4 justices are like, well, it doesn't say that. That's not what Congress want. And the majority is basically like, well, Congress didn't say they didn't want it, and they adopted background principles, and we think that it's intertwined, and therefore we think all these things. I totally understand the dispute. I totally understand why it's split. I'm not sure which way I would come down on this. I'd probably bet I'd come down in the dissent on this issue, but it's a very interesting issue with trying to read exactly what a statute had in mind. So all those things. We also have to consider broader purposes relating to the PLRA and making that decision as well. So, yeah. All right, so those were all the decisions that came out on the 18th. What else we got? All right. Habeas petitions. Fun. Habeas petitions for the win. The conservative justices made it easier for a prisoner. No, it's mostly the liberal ones. It was Roberts, Sotomayor, Kagan, Gorsuch, and Jackson. Interesting, Gorsuch wound up in the majority on that one. Interesting, because he's a very sort of straight textualist kind of guy. So interesting, Gorsuch wound up in the majority. Barrett delivers an opinion in which Thomas, Alito, and Kavanaugh dissent. Interesting. Interesting split. Well, let's do this habeas petition thing. We turn our attention to Rivers versus Guerrero. Petitioner Danny Rivers was convicted in Texas court of continuously abusing a child in a prurient way and related charges. After seeking unsuccessfully direct appeal and state habeas relief, Rivers filed his first federal habeas petition asserting claims of prosecutorial misconduct, ineffective assistance of counsel, and other constitutional violations. The district court denied the petition, and Rivers appealed to the Fifth Circuit, which granted a certificate of appealability on the ineffective assistance of counsel. While his appeal was claiming, Rivers obtained his trial counsel's client file, which contained a state investigative report that he believed was exculpatory. After the Fifth Circuit denied his request to supplement the record on appeal, Rivers filed a second petition in district court based on the newly discovered evidence. The district court classified the second in time filing as a second or subsequent habeas petition and transferred to the Fifth Circuit for authorization to file. Rivers appealed the transfer order, and the Fifth Circuit affirmed, holding that the fact that Rivers' first petition was still on appeal did not permit him to circumvent the requirements for second or subsequent petitions. All right. So you get basically one bite at the apple in habeas. So what exactly is one is the issue. When does one stop? When have you had your one? That's the question. What is the line of demarcation? All right, cool. Once a district court enters judgment with respect to the first habeas petition, a second filing qualifies as second. So that's the line of demarcation when the district court renders its decision. So, whatever happens on appeal happens, but that's the line of demarcation. You've had your one once the district court renders a decision. Okay. The Anti-Terrorism and Effective Death Penalty Act contains several significant procedural bars that strictly limit a court's ability to hear claims in a second or subsequent petition. Relevant here, it prohibits habeas applicants from filing a second petition that relitigates the merits of a previously denied claim. Even if a subsequent petition presents a new claim, the second in time application can proceed only if it relies on new and retroactive rule of constitutional law or alleges previously undiscovered facts that will establish innocence. In addition, a petitioner cannot bring a second petition habeas directly to the district court, but must first go to the Court of Appeals and make a prima facie showing the petition satisfies the exception. The court has jurisdiction to review the dispute, one would hope. Respondent contends that Rivers lacks standing because the Fifth Circuit now has affirmed the district court's judgment denying the initial habeas. But because a favorable decision here would readdress the injury, the district court inappropriately transferred the second petition. Rivers has appellate standing with respect to the claim. Nor is the fact that Rivers is no longer in custody on the conviction that his second habeas file challenge defeat the court's jurisdiction, given that Rivers remains incarcerated on a different sentence that the newly discovered evidence may implicate. The phrase second or subsequent petition is a term of art that does not refer to all filings made second in time. Whether a filing qualifies as second or subsequent generally turns on the existence of a final judgment with respect to the first petition, not the status of the appeal. An amended petition filed before judgment is not second because final judgment has not been issued. So if you amend the petition while still pending, that is not a second petition. That's just an amended petition. But once it's final, it's final. So yeah, all those things, man. All those things. 693 of you currently watching. Will you be so kind as to give me a moment of pause? I need to get water, so I need to pull a Marco Rubio and get some water because my palate's a little dry. I will be right back. Talk amongst yourselves. All right, guys, thank you for the brief break. Let's resume where we were. All right, Rivers' argument, his second filing should not trigger the relevant law because his appeal was pending is unpersuasive. The court's decision in a different case does not support a rule that is based on appellate timing, but rather confirms entry of final judgment generally separates first from second habeas petitions. The relevant Rule 39E motions present a unique variant because they suspend finality, help produce a single final judgment, but Rivers does not fall within that category. Purpose and history do not support Rivers' interpretation either. The relevant law restrictions aim to conserve resources, reduce piecemeal litigation, and lend finality to state court judgments within a reasonable time. Drawing the second or subsequent line at the end of appellate review would allow petitioners to find numerous applications during appeals, prolong cases, and encourage piecemeal litigation. Historic habeas doctrine before AEDP was inconsistent regarding treatment of new filings pending appeal, providing no clear guidance. The court declined to address whether Rivers' alternative argument that his second filing, which he argues is Rule 15 motion amend, is not new by nature. Theory is not presented in the petition for cert or the court's below makes an appearance in the merits briefing. Additionally, the factual predicate is lacking because the district court lacked jurisdiction to grant a motion while the case is on appeal and never requested a ruling under some other rule. And Jackson delivers an opinion for a unanimous Supreme Court. So all that is fine. So I understand all those things. That's easy enough. All right, let's see what else do we have today. Catching up on Supreme Court stuff. All right, something dealing with tax court. Exciting, taxes. Thank you, by the way, for the 557 of you who are currently here. If you haven't hit the subscribe button already, now would be a good time. I really appreciate you spending some time with me. I hope you're learning some fun stuff about law. And all that good stuff. Let's do another case. All right. This case involves jurisdiction from the United States Tax Court over appeals from collection due process hearings when there's no longer an ongoing levy. The dispute here began in 2012 when Jennifer Zuck and her then husband each filed an untimely 2010 federal tax return. Gennaro subsequently submitted an offer to compromise to resolve his outstanding liability. This offer implicated $50,000 in estimated tax payments the couple had previously sent to the IRS. Okay. Following that offer, the IRS applied these payments to Gennardo's account. For her part, Zuck later amended her 2010 tax return to report additional income, which resulted in additional $28,000 in tax. But Zuck maintained that the IRS should have credited the couple's $50,000 payment to her account, entitling her to a $22,000 refund. The IRS disagreed and sought to collect her unpaid taxes by placing a levy on her property pursuant to law. Zuck requested a collection due process hearing to contest the levy. The appeal officer rejected Zuck's argument about the misapplied tax payment and issued the notice of determination surrounding the levy. Zuck then appealed to the tax court. During the multi-year proceedings before the agency and the tax court that followed, Zuck filed several annual tax returns showing overpayments. Each time the IRS applied these overpayments to her outstanding 2010 tax liability rather than issue refunds. Once Zuck's liability reached zero, the IRS moved to dismiss the tax court's proceeding as moot, arguing the tax court lacked jurisdiction because the IRS no longer had a basis to levy the property. The tax court agreed, but on appeal, the Third Circuit vacated, holding the IRS abandonment of the levy did not moot the proceeding. Hell, the tax court lacks jurisdiction to resolve disputes between a taxpayer and the IRS when the IRS is no longer pursuing the levy. The tax court is a court of limited jurisdiction. The relevant law grants the tax court to review an appeals officer determination in a collection due process hearing. The scope of the determination determines whether the tax court has jurisdiction to review. The court agrees with the government that the determination refers to a binary decision about whether the levy can proceed. The relevant law requires the appeals officer to consider three things when making a determination, including issues. Can I cut the thing from yesterday? Sure. Consideration that informed the determination. Here, Zuck's dispute about estimated tax payment was an input in determination the issue raised the appeals officer is required to consider under the relevant law. Termination, by contrast, was just the appeals officer's decision to sustain the levy. Statutory context also supports the government's position on limited scope. When a taxpayer wants to contest tax liability, default rule requires taxpayers to first pay disputed tax before pursuing a challenge. Here, had the IRS simply offset the overpayments without pursuing the levy, her only recourse would have been a refund suit in line with the default rule. The IRS proposed levy triggers the right to collection due process hearing, but the relevant law, titled Notice and Opportunity Hearing Before Levy, focuses on just the levy. The hearing scope tracks its purpose. Taxpayers may raise only levy-related issues. Given the unwavering focus on levies and the default rule requiring post-payment suits, it'd be strange if a taxpayer could use the appeal to resolve tax disputes that no longer have ongoing connection to the levy. Finally, the court doubts tax courts have authority under the relevant law to provide relief beyond enjoining the levy. Nothing in the relevant law authorizes the tax court to offer refunds or issue declaratory judgments resolving the liability. While Zuck argues the authority to enjoin the levy necessarily includes the ability to declare the validity of the underlying tax liability, the tax court's authority to render such conclusions depends on the levy's existence. The tax court properly dismissed the appeal. The appeal officer's issued determination the IRS proposed levy could proceed. The tax court had jurisdiction to review the determination, determine whether or not the levy could go forward. As part of that review, the tax court initially had authority to determine whether the appeals officer's predicate conclusion, like whether the $50,000 should have been credited exclusively to Gennaro, were correct. But once Zuck no longer owed unpaid taxes, there was no basis for levy and thus no determination review. The tax court lacks jurisdiction to opine. The recourse for alleged tax overpayment is to file a refund suit, which she's already done. So fair enough, she can get a refund that way. Barrett delivers her opinion in a court in which Gorsuch disputes in an 8-1. Pay before you dispute doesn't sound fair? Well, welcome to the law. Yeah, you have to pay them and then sue them. You have to pay them and then sue them. Yeah, that's the law. Yep. All right, great. Moving on. What else do we got today in our catch-up stream? We did the wrong house raid thing. We discussed that already at some length. Let's see, Parrish versus United States. Okay. Something dealing with prisons. I'm not quite 100% sure what this is, but let's see what it is. All right, we turn our attention to the U.S. Supreme Court, Parrish versus United States, from the Fourth Circuit. Federal inmate Dante Parrish alleges that he was placed in restrictive segregated confinement for 23 months based on suspected involvement in another inmate's death. After the hearing officer cleared him of wrongdoing, he filed suit in federal district court seeking damages for his time in segregation. The district court dismissed the case, holding that some claims were untimely and others unexhausted. When the court's order reaching the federal prison, when the court's order to reach the federal prison 2 weeks later, Parrish was no longer there, having been transferred to a different facility. Parrish received the dismissal order 3 months after it was issued and promptly filed a notice of appeal explaining the delayed receipt. The Fourth Circuit recognized that Parrish's notice of appeal came well after the 60-day appeal period for suits against the United States, so construed Parrish's filing as a motion to reopen the time. On remand, the district court granted reopening for 14 days. Parrish did not file a second notice of appeal. Although Parrish and the United States argued the original notice of appeal was sufficient, the Fourth Circuit held that Parrish's failure to file a new notice of appeal within the reopened period deprived the court of jurisdiction. Held, a litigant who files notice of appeal after the original appeal deadline, but before the court grants reopening, need not file a second notice after reopening. The original notice relates forward to the date reopening is granted. So if you file an appeal too late, and they're like, it's too late, and I'd really like another go, and they say, okay, you don't have to file another notice. Like, you already filed one will be fine. Civil litigants must ordinarily file a notice of appeal within 30 days of entry or 60 days when the United States is a party. In civil cases, the requirement to file timely is jurisdictional. Congress required to create 2 exemptions. Court may extend the appeal time upon showing of excusable neglect or good cause, and courts may reopen the time for appeal when a party entitled to notice does not receive it. Here, there's no dispute the district court reopened the time to appeal. The relevant law establishes that a reopened appeal period runs for 14 days from the date of entry of the order reopening the time for appeal. A notice filed after the 14 period is late, meaning it can no longer serve the purpose. A notice filed before reopening is granted, however, is merely early. While statutory text does not address the jurisdictional consequences of premature filing, Congress has legislated against a background of common law principles which apply unless a contrary statutory purpose is evident. This court has long held that premature but adequate notices of appeal should relate forward to entry a document that makes an appeal possible. For over a century, the court has consistently applied the principle to avoid dismissing appeal based on mere technicalities when no genuine doubt exists about who is appealing from what judgment and to what court. This practice with regards to premature notices does not change when Congress passed the first version of the relevant law or when the federal rules of appellate procedure were subsequently promulgated. The text itself provides no indication of Congress sought to terminate the long-standing relation forward or disturb its development. Applying the relation rule forward, parish note relates forward to the date. By the way, incidentally, if you have topics you want us to discuss, the best way to do that is via our Discord. We have a nice channel in our Discord for topic suggestions. That would be by far and away the best place to provide the suggestions because it provides them in one consolidated place. Sometimes people email me suggestions and then I kind of forget they exist because that's why I have the Discord, or they mention them in YouTube. And then I kind of forget they exist because they're not on the Discord. So if you have a story suggestion, probably the best place to put it is in the story suggestion folder in Discord, because then I can look at it and be like, oh yeah, that's right. That's what someone suggested, because sometimes my memory is a bit like a sieve. So join the Discord and provide your suggestions there today. And you can also engage just generally with the channel that way. That's good stuff. Counter arguments are unpersuasive. While the word reopen presumes appeal period is closed, this merely confirms the parish notice was premature with respect to the reopened period. It does not resolve whether notices should relate forward. The characteristic notice as of late rather than premature fails to recognize there are two periods to appeal, the original 60-day and the 14-day reopen period. The Fourth Circuit concern is that a single filing cannot serve dual purposes is contradicted by precedent recognizing the one document can simultaneously function as both a notice of appeal and other filings. So yeah, one document can do more than one thing. The federal rules of appellate procedure support this result. The rules codify the principle that premature notices should relate forward when they do not prejudice opposing parties. The 1993 amendment eliminating restrictions on relating forward was specifically designed to avoid creating a trap for unsuspecting litigants and to address the problem many litigants, especially pro se litigants, failed to file a notice of appeal. The rule's silence on relation forward does not create a negative implication prohibiting it, particularly given the rule's emphasis on securing just, speedy, inexpensive determination of every action or proceeding. Sotomayor delivers the opinion of the court in which Roberts, Alito, Kagan, Kavanaugh, and Barrett join. Jackson delivers an opinion in which Gorsuch dissents. So Gorsuch again in a dissenting mood today. All right. I'm running a little bit out of steam, so I'm not sure if I have much more in me today, although I do have an interview with someone else in about a half hour. So I'm doing an interview with a psychologist, I think, in a half hour, online stream. And that'll be fun. We're doing an interview with this woman, Dr. Anna Rosnawaski. There's no way I'm getting that right. And she wanted to do an interview relating to psychology, relating to the Karen Reed thing. And so I'm going to do that in a half hour, and that will be fun. And incidentally, by the way, we did do the merch giveaway, as you guys noticed, and we had all eight members sent me the email, and all 8 members have gotten their code, and so great. All those things. And okay. Let's see if there's anything else today. I've got time for one more. All right, let's do this one. One more case on my channel. But I've been making timestamps as we go along. I've been pressing the timestamp button, so hopefully all those timestamps will be preserved after the video ends, because that's why I've been pushing the button. That's what it's supposed to do. So we'll see. There's a reason for the button, right? You're welcome, Zark. I hope you like your merch. We turn our attention to Soto versus United States. The Bearing Act establishes default settlement proceedings for claims against the government and subjects most claims to a 6-year limitation. However, the act includes an exception. If another law confers authority to settle a claim against the government, that law displaces the Bearing Act settlement mechanism, including its limitation period. In 2002, Congress enacted a statute providing combat-related special compensation to qualifying veterans who suffered combat injuries. Under federal law, retired veterans generally must waive a portion of their military retirement pay to receive Veterans Affairs benefits, but the statute allows combatant disabled retirees to receive special compensation up to the amount of the pay. Okay. Petitioner Simon Soto served in the Marine Corps from 2000 to 2006, including 2 tours in Iraqi freedom. He was medically retired in 2006 and later received a 100% disability rating for post-traumatic stress disorder. In 2016, Soto applied for payments. The Secretary of Navy approved his application, but limited retroactive compensation for 6 years, citing the Bearing Act limitation period. Soto filed a class action lawsuit arguing the Bearing Act's 6-year limitation period does not apply to these claims because the statute constitutes another law that provides its own settlement mechanism. The district court granted summary judgment for the class, but the federal circuit reversed, holding the statute does not explicitly grant settlement authority and therefore cannot displace the Bearing Act. How do you do it in StreamYard? I have no idea how you do it in StreamYard. I'm just on YouTube's backend. There's a little button you can press on YouTube's backend to make the markers. So how you do it in StreamYard is beyond me. Held, the CRSC statute confers authority to settle claims and thus displace the Bearing Act settlement procedure and limitations. The term settle in the government claims context refers to determine the validity of the claim and the amount of money is due. A settlement confers settlement authority so long as it vests an entity with these powers. While the most straightforward way to confer settlement authority might be to use the term settle, Congress does not use magic words. To determine whether a statute constitutes another law that displaces the Bearing Act settlement procedures, court must examine text, context, and structure of the entire statutory scheme to analyze whether the law confers authority to determine both the claim's validity and the amount due. The CRSC statute meets these requirements. Law confers upon the Secretary the authority to pay each eligible claim a monthly amount determined under the statute's terms. Regarding validity, the statute provides the Secretary concerned shall consider whether the applicant is eligible for the disability payments. Because the Secretary shall pay the payments to each eligible veteran, determining the claim's eligibility is tantamount to determining the validity of the claim. Statute also confers authority on the Secretary to determine the amount due by instructing the Secretary to take a specific amount. Taken as a whole, the statute establishes a unique, self-contained, comprehensive compensation scheme that authorizes the Secretary concerned both the validity of the claims and the amount due, thus creating a separate settlement mechanism that displaces the Bearing Act. The Federal Circuit erred by imposing undue requirements on Congress's ability to confer settlement authority and by disregarding the text. The court's demand for specific language and its alternative requirement statute provide a specific limitation period to displace the Bearing Act are rejected. Congress need not use particular words to confer settlement authority, and this unique statutory regime is not a reasonable thing. Congress would have provided a settlement mechanism without a specific settlement period. The government's arguments for affirmance are similar, unpersuaded, including insistence on hallmarks to confer settlement authority and concern about destabilization. The separate subsections in combination create a comprehensive benefit scheme that authorizes the Secretary to confer both the validity of the claims and the amount due, and Thomas delivers a unanimous opinion for the court. And that brings us to the end of our stream, and we will be back on in about 30 minutes. So, all those things. I'm still a little tired. I'm not going to lie. I am still a little tired. Where are the sunglasses I ordered, incidentally? Oh, they apparently arrived. Okay, hold on one second. Apparently, I've got new exciting glasses that are supposed to help with eye strain issues. So we're going to put them on, and see how stupid I look. Okay, give me 1 second, please. I don't know. I'm not sure about any of that. These are the cheap ones I got from Amazon. The more expensive ones are being shipped to me at my P.O. box, but these are the cheap ones. These are FL41 tinted glasses, apparently, that are supposed to help with eye strain. I don't know about any of that. I don't know about any of that. They work, you think? They look okay, but do they work? I don't know whether or not they work or not. I don't know. Looking hot? I mean, they definitely changed the color of things. Whether or not that's helping the issue, I don't know. It's supposed to help provide relief from light sensitivity. I don't know. Yeah, I don't know. I feel dumb. Maybe these ones were like $12. Maybe the $120 ones I bought that are going to arrive in a couple days will be better or whatever. We'll see. We'll see how it works. I don't know. We'll see how it works. But I'll get back to you. According to the description, these reading glasses are equipped with specialized FL41 lenses that help to block blue light and fluorescent light, making them ideal for those who experience migraines, light sensitivity, and photophobia. Lens technology is designed to block specific wavelengths that may trigger discomfort, providing potential relief and protection in types of indoor lighting and outdoor versatility. Whether you're dealing with harsh office lighting or bright outdoor conditions, the FL41 tinted lenses are suitable for both. I don't know. All right. Well, in any event, I'll get back to you guys. I'll see you guys in a half hour. For the moment, I've been Uncivil Law. I'll talk to you soon. Cheers, my friends, for now, and